Hey, 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 all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, within and for the Commonwealth. Draw near, give attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone, and welcome to the Appeals Court. My name is Amy Blake. Today I'm joined by my colleagues Justice Massing and Justice Hand. We are your panel for the 5 cases that we will be hearing this morning. Most of you have been here before, but I will briefly go over the rules. Each side is permitted 15 minutes of argument. There is no rebuttal. I know that you know this, but we have read all of your materials, so it behooves you to get straight to the issues. For the first case, it is docket number 23P273, Department of Children and Families and Another versus Father. Remind the parties that the names of the individuals are impounded, so please don't use any names. And I just want to make sure I understand as to the appellees, the department is arguing for 8 minutes and the child for 7, is that right? Okay. So with that, counsel, when you're ready.
But father gets 15.
Yes, father gets 15, so we just need to fix that on the clock.
There we go.
Great. Thank you.
Good morning, and may it please the court. I'm Charles Levin for the father.
Hold on. Oh, there we go. Great. Just needed that green light.
And again, Charles Levin for the father. May it please the court. Is a parent fit by virtue of the fact that their own parent is ready and available to assist them in their parenting obligations? Father would argue that the answer is affirmative. Father's mother was, in fact, such a support and identified herself as such at trial.
Can I just pause you? I want to make sure I heard you properly. Are you suggesting that if father is unfit, we can consider him fit if he's going to parent with his own mom?
That is what I'm suggesting.
Do you have a case that says that?
Well, as I indicated in my brief, I don't believe that there is a case on point yet in the Commonwealth. What I did include in my record appendix was the decision from the Department of Justice Civil Rights Division and Executive Department, the Health and Human Services Office for Civil Rights, which decided a very analogous case. And I think that it's particularly strong guidance because these are cabinet-level executive departments of the U.S. government that have oversight authority over civil rights, ADA issues, and exercise that in a case very similar to ours involving DCF in Massachusetts. That case is included in the record appendix and involved, as does this one, the removal of a child from a person with a cognitive impairment. And what the Department of Justice and Health and Human Services found in that case was that DCF failed to make the reasonable modification of actually allowing or obligating DCF to consider the role of that cognitively impaired parent's own parent in being able to parent this child.
Was there a specific accommodation that your client sought in this case that DCF did not grant?
So the short answer, Your Honor, is no. He did not seek specific accommodations. He did
is
speak.
The issue therefore waived?
No, because he sought accommodations through his attorney. And one of the problems.
Well, I guess that's what I just asked you, though, right? Whether it was him or his attorney. Did somebody ask in the lower court proceedings for the father to have accommodations and that those were not granted?
Well, I think your question was specific accommodations. I'm just cutting hairs here because he didn't ask for a specific accommodation. He asked for accommodations. And one of the problems.
Without specificity.
I'm sorry?
Without specificity.
Well, yes, and part of the problem here, and this was going to be the second thing that I was going to talk about, but I'll get to it now as a result of your question. The department had filed a motion which was approved by the trial judge for this father to have a neuropsychological evaluation. And it was for the specific purpose of determining what kind of accommodations would be appropriate for him, so that would help the department in being able to help him towards the goal of reunification. The trial happened before that evaluation could take place. He, as is typical, he was put on a waiting list, spent some months on the waiting list. That didn't resolve by the time of trial. His counsel, his trial counsel, actually filed a motion in the trial court to continue the trial until that evaluation could take place. That was denied.
Counsel, was that the second such evaluation that your client had been scheduled for?
Yes. So there was a first evaluation scheduled by his attorney. In the materials, the record indicates that he showed up for the evaluation. He lasted for less than a day and he left. So here, with this impending evaluation, he testified at trial. He would attend it. There was really no further evidence about it but that. I think there is no reason not to take him at his word. How about
the fact that he hadn't cooperated with DCF at all during the entire pendency of the case? Isn't that a reason not to take him at his word?
Well, that would be reason to take him at his word, except that I think that the fact that he testified honestly at trial about what he didn't do, the services he didn't do and why he didn't do them, which really was for no reason at all, he said.
And what, so basically, what was his testimony the reason he didn't do the services?
I think, the testimony really amounted to no more than he didn't really have a good reason for not doing them, quite honestly. I can't stand before you and make a case that he had good reasons for not doing them. What I would like to impress on you is simply that while he was willing to testify against his own self-interest very forthrightly, he also testified that he was very willing to engage in the second evaluation. And so I think that for that reason, I don't think there's particular reason to doubt it, although I acknowledge that his track record with services was not good. Be that as it may, that was a big issue with regards to this appeal, because the department itself identified that had he been able to engage in the second evaluation, that could have lent itself to the formulation of accommodations that could have helped the department as well as father move forward. And
can I ask you about back to earlier in the argument, you were talking about the DOJ report, and the department distinguishes it, and I read it myself since you provided it in the appendix, and it seems to me that and correct me if I'm wrong, if I'm seeing this wrong. It seems like in that DOJ case, the person that they gave the pseudonym of Gordon, Ms. Gordon, was a mother with intellectual disabilities who really wanted to parent her child, and she needed her parents' help. Whereas it seems like in this case, the father really doesn't want to parent his child. It seems like but more like the grandparents would be parenting the child with father's help whenever he feels like it. And tell me why that's not a correct reading of this record.
I don't know that it's an incorrect reading, Your Honor. What I would argue is that that's not really the dispositive issue here. That even given what appeared on the record to be sort of a lack of interest on father's part, my reading of the DOJ's case is that so long as you have a father who's available and doesn't articulate, this father didn't, I don't think he articulated in explicitly, I don't want this child. Once he was adjudicated for paternity, he did. He was verbalizing that he wanted to. I think under those circumstances, what's important about that administrative case is the fact that those authorities recognized the role of the essential role of modifications under the ADA in a situation like this where you have a parent who does have impairments, acknowledged impairments, and I think it's important to also acknowledge father himself didn't acknowledge them, but his counsel did. And DCF was well aware of them. That's why they filed the motion in June for the evaluation.
But can we go back to the question and answer that you just gave to Justice Massing? If he wanted to parent, one of the ways to demonstrate that is in his visitation with the child. And there's some pretty extensive findings about his inconsistency, his ignoring the social worker's call to even schedule the visit, that the judge found that he didn't establish a bond with the child on the times that he did. He would leave the visits to get food. He interrupted, talking about things like the child's name. How are those findings, which you don't suggest are erroneous, how are those consistent with the father's view that he wants to parent?
Your Honor, I can't get around those findings, but the reason that I included adoption of Lynn in my materials is because that was perhaps the only case, the only one I've been able to find that presented a similar circumstance where it was actually found that that parent whose profile seemed to match very closely the profile of my client, that the evaluation that did take place there, a similar neuropsychological evaluation, showed a correlation between the parent's comprehensive lack of engagement and the disability. And I think that that's really profound because had the neuropsychological evaluation taken place here, it well might have found the same thing. And where the parent's very disability manifests itself in his or her inability, for whatever reason, based on disability, to engage in services, that's something that I think the agency needs to understand and work with. And that's what the hope was here in having this completion of the neuropsych evaluation to allow that.
Was there a specific tie that was expected to come out of the neuropsych evaluation had it taken place between the lack of engagement and the father's deficiency?
I'm sorry, were there specific findings that were anticipated?
Maybe another way of putting that is, it sounds to me like it may be a hope that something would come out of the neuropsychological evaluation had it taken place, but I'm not seeing in the record an indication of what exactly was anticipated to come out as that connection, how that was, the neuropsych was going to provide a link to additional services. Is there something that I'm missing in the record about that?
Well, the neuropsych evaluation that was scheduled did not, what I would say is there's nothing in the record that anticipates explicitly what the results of that evaluation may have been. I'm inferring, based on my reading of adoption of Lynn, that this presents an analogous circumstance in conjunction with the department's stated language in its motion, which I've cited in my brief, which was very explicit about, we need to know more about this guy so we can plan for him, so we can actually make reasonable, so we can make the right reasonable accommodations. They reasonably accommodated. There's no question about that. But the question is, were the accommodations suitably matched with the disability? And without having this evaluation, that's the answer that is still sort of blowing in the wind, if you will.
Can I just parse that last statement? You said they did reasonably accommodate him, but maybe they gave him the wrong accommodations?
Wrong or incomplete accommodations. I acknowledge the accommodations they provided in my brief, and those were reinforced in the appellee's briefs. They made a number of accommodations in good faith. There's no doubt about that. But again, with ADA or Section 504 accommodations and per DCF policy itself, accommodations need to be correlated to identified deficiencies. And without knowing exactly what those identified deficiencies are, we just don't know exactly how to do it. And that's, again, the reason that that evaluation was potentially going to play such a prominent role. And it's really unfortunate that it wasn't allowed to go forward. If my client didn't show up for that, end of story. But giving him the benefit of the doubt of had he shown up, we would have had a much better idea of what specific accommodations may have actually worked in order to engage him and allow the case to move forward. I'm just about out of time. Unless I have other questions, I'll rest on my brief.
Just want to make sure. I see no others. Thank you very much.
Thank you.
Attorney Murphy. Good morning.
Good morning. May it please the court, Lynn Murphy for the Department of Children and Families. I'll be arguing 8 minutes, and counsel for child will get the other, argue for the other 7. The department asks this court to affirm the trial court's decree in this case because father's unfitness is undisputed and overwhelmingly established. The ADA does not change the standard of fitness. What the ADA endeavors to do is make it easier for people with disabilities to engage in services and activities to reach that level of fitness. In this case, the department provided every service it could think of and made numerous referrals to many different organizations, other agencies, and father refused to participate. He also consistently denied he had any disability, and this is why he didn't want to participate in services, because he didn't feel he had a disability.
But the department knew that he was receiving Social Security, which at least puts you on notice that there may be some issue. His mom suggested that he was under some sort of guardianship, although not court-ordered. We know at some point he was appointed a GAL next friend, so you were on some notice.
Yes, absolutely, and that is what the department used to tailor its service plan, and that's why it identified the services that it did. The Strong Fathers Program, the application for DDS services. There were several different referrals made, but what the department, despite its efforts, if the parent doesn't want to participate and continues to deny that it has a disability, it's very difficult for the department to provide any other services. And I will point out the department not only worked with father, but his mother, and tried to be very clear what the department was expecting and looking for as far as father was concerned. But the issue, as we have clearly see here, is a father was not interested in parenting the child. Even though he said otherwise, his demeanor and his actions clearly showed he expected his mother to provide care for the child. So at that, there's very, very little the department can do to motivate a parent to become interested in his child and prioritize that child above other needs. And again, the department did everything it could to try to get father to visit, reminded
Going in a
him.
different direction for a second. I know that it was permanency through maternal grandmother. Was that guardianship or adoption?
The maternal grandparents will be adopting.
And there is a visitation would be within their discretion.
Yes, and there's indication that they would do so, and I think the department's still providing. Father stopped visiting about a month before trial, but I think the department continued to offer him visits, so he would be able to visit the child and have some kind of presence in his life, in his child's life, I should say. Well, I don't know what else to say other than
So you said yourself that the father denied disability, and Attorney Levin said the disability is what prevented him from engagement. There's sort of a chicken and egg problem here, that he can't be accommodated because he won't accept the accommodations, and then because he doesn't have the accommodations, he can't accept the. So how do you address that? I mean, is that just evidence of unfitness, or what?
Well, I think the problem becomes, again, people have protections. They don't have to engage in mental health activity services, nor do they have to even admit that they have a disability or some health issue. So the department's faced with trying to provide services to somebody who is just adamant and not going to disclose that information. And even the notes that the evaluator took, that counsel for father set up, counsel didn't want those notes in and argued that they were work product. And I don't know that the notes would have been very helpful, but again, this is what we're seeing, a protection of people's rights to privacy. But in the meantime, we have a child who's been in limbo, so to speak, for 19 months. And at a certain point, the court must act to protect those best interests of the child for permanency. And in this case, this child's needs and deserves termination because permanency with the maternal grandparents is certainly meets the child's best interest and was appropriate here. If there are no further questions, I will rest on my brief.
I don't
Ask
see
you
any,
to
thank
refer.
you.
Thank you very much.
Attorney Campbell.
Excuse me. Good morning. May it please the court. My name is Alan Campbell, and it's my privilege to represent the subject child in this matter. And the subject child asks that this court affirm the judgment below in its entirety so that he may be adopted by his current placement with maternal grandfather and maternal grandfather's wife. I'd actually like to start just by following up on some questions you have had for father's attorney. And first one with Justice Blake's question about whether this issue is raised. Father did not present this below. Barely 2 months before trial, father's counsel sent a letter to DCF asking for reasonable accommodations, and then there was some correspondence back and forth, but there was never any grievances filed with DCF. There was no motion for abuse of discretion.
So I assume that there then was not a abuse of discretion motion under Daisy.
Exactly. And by this time, he was on, you get a service plan every 4 months, so I believe, so 0, 4, 8, 12, 16. Trial was 18 months in. He was on his 5th service plan at the time of trial, and at no point had he complained that he wasn't being offered reasonable services, and I believe I heard father's counsel say that he was reasonably accommodated.
But they weren't the right ones, or they were incomplete. So what do you say to that?
Well, that's an argument he's made. There's no evidence in the record below that that's true. And that would be because father did not participate in any services. And in the correspondence from DCF, the unit responsible for making accommodations said, if you have any information to present to us, you think we're doing something wrong, let us know. And father did not provide any such information. Again, father regularly denied that he had a disability, even though it's clear he had some sort of disability. And he refused to participate, to give DCF any more information, which in a sense puts the argument at, yes, I said I didn't have a disability, but I did, and it's your fault that you didn't figure out what it was, which is really a tough position to put DCF in. When they made many accommodations that probably would have been sufficient, but certainly were sufficient to find out, what was going on and to help him, had he participated in these services. And I believe there are 5 services. They offered to assist him with applying to DDS. He refused to do that. They referred him to Northeast ARC. He was ineligible for that because he refused to apply for DDS. They referred him to a fathers group. He refused to participate in that. I believe specifically, even though the fathers group reached out to him to complete an intake, he was working on his cars and he was too busy to call them back. And they referred him to therapy. He refused to do that. He was on the waiting list for an evaluation, but he had already begun an evaluation and decided that he wasn't going to continue that.
Was there ever any evidence in the record about why he qualified for Social Security benefits?
I believe there is something about a cognitive delay, but that's it. The father offered no evidence. He didn't call an expert or offer evidence as to the delay. So again, the issue regarding reasonable efforts is waived in the first instance because he didn't raise it timely. And the second one is that DCF's obligation to provide services and accommodations is dependent on fathers engaging in those services, and father did not engage in the services he was offered. DCF made reasonable efforts. And then finally, of course, I believe it's West says even if DCF doesn't make reasonable efforts, that doesn't lower the bar for parents' fitness. If the parent is unfit, the court is still required to rule in the child's best interests. And then to follow up on a question Justice Massing had, and I already touched on this, the reason father didn't visit and is actually in the record, and that's he was very interested in his cars. He frequently would choose to work on his cars rather than parent or attend visits, rather. There was one instance where father was living in Western Mass, and he said, he was offered a visit in Eastern Mass, I believe in Lawrence area, and he said, I can't be expected to drive all that way for a visit. And then that weekend, he was seen at his mother's house in Lawrence washing his car. So he was willing to drive 3 hours to wash his car, but not to see his son. And I believe he also testified even...
You could see that as a manifestation of a disability, though, too, couldn't you?
You could, certainly. But again, when you have a disability, that doesn't lower the bar. You still need to be able to parent your child. He also at times said, even when I'm not working, I'm always busy. I can't be expected to drop everything to visit my son. And then he hadn't visited for some time before trial because, and I believe this is, I believe there were custom door panels he was working on, and that was taking up his time, so he wasn't able to visit with his child. Look quickly at my notes, and unless there are any other questions, I'll rest on my brief. Let me just reiterate, this child would love to be adopted by the family that has raised him for the last 3 years since he was approximately 7 days old.
Let me just check with the panel. Seeing none, thank you very much. It's a difficult case, as are all of these cases. Your arguments were quite helpful, and the case has been submitted. Thank you. Next case is HILARY AROKE, I apologize if I've mispronounced that, versus the Massachusetts Board of Registration in Medicine, docket 22P0884. When you're ready.
Good morning.
Good morning, Mr. Rosen.
May it please the court, my name is Joel Rose and I represent HILARY AROKE. Dr. AROKE, this case is interesting because it gives the court a chance to clarify some confusion about the HIS case and also to give some guidance to licensing boards in reinstatement cases. Dr. AROKE was found liable of serious misconduct. This was a case where there were no witnesses. He has consistently denied that he committed the misconduct, although he recognizes, of course, that it's legally established that he did. But he has consistently denied it. The board, on the basis of the findings that he did commit the misconduct, the board suspended him. When he came back and asked for reinstatement, the board declined based on the fact that this was a serious misconduct and that he had not, in their words, taken responsibility for his actions. The board's position was identical to the position of the Board of Bar Overseers in the HIS case, who came before this, I think, the Supreme Judicial Court and said, when the misconduct is serious, and the licensee refuses to admit it, reinstating them is a logical impossibility. And his court said, no, that's not correct. Neither of those statements is correct. First of all, his court said, there is no misconduct that is so serious that the doors of redemption are closed to the licensee. And it also is recognizing that the basic principle that our licensure system is not designed to punish, but to protect the public. And the question is not how serious was the original misconduct. The question is, would the person do it again? Has the person shown good character now?
Let me ask you a little bit about that, going back a time, because as I understand it, one of the patients, after the disclosure, the hospital, I believe, required your client to have a chaperone present at all times. And then when the allegations came from the next patient, it was uncontroverted that there was no chaperone present. So in terms of sort of being on notice and his subsequent acts, it appears from this record that he continued to offend.
I think that in the first situation, the hospital recommended a chaperone but did not require one. I think that's what you'll find in the record.
But at record 48, it says that your client accepted that recommendation. So I take that he said, we'll have a chaperone, and then in fact didn't, and a new allegation arose.
Okay. I don't think I mean, we're talking about two incidents that happened in 2006 and 2007. So, the most recent is 16 years ago. So he continued to practice for 5 years after that.
Just before we leave that, so I was a little confused with the timeline. So you're agreeing there was, between the two incidents, there was discussion of chaperones.
I believe that that's what Justice Blake found in the record.
Well, you should know the record better than her.
Yes.
Is she correct about that?
I think that what happened is that the hospital said you should, after the first report, the hospital said you should have a chaperone, and that was a recommendation, not a requirement. As Justice Blake pointed out, Dr. AROKE accepted the recommendation.
Because it seemed then then after the second incident there was a requirement of a chaperone?
Whether it became a firm requirement or remained a recommendation, I honestly can't say.
Well, record 48 says, North Shore Medical Center required your client to have a chaperone present after the second reported incident, whether it be in the hospital or in his private practice.
All right.
And that he did so most of the time, but not consistently. So he didn't follow the rules now on the second notification.
That's true.
So thinking about getting his license back, putting aside the question of whether he's required to admit his misconduct or not, if a hospital or a facility puts rules in place for patient safety, we have at least 2 demonstrated incidents where he didn't, after being made aware of the fact that there were these serious allegations. Whether they were true or not, it seems to me he would say, I'm not going to put myself in a position to have a third allegation, although I know there was a third allegation that the board did not rely on. He's given a suggestion and then a requirement to have a chaperone present, and he doesn't always do it. So his license is reinstated, hypothetically. If it was conditioned upon him having a chaperone, he has a demonstrated practice of not following that requirement. Doesn't that put patient safety at risk?
Sorry, I didn't hear your question.
Doesn't that put patient safety at risk?
It certainly, well, I don't think it puts patient safety at risk. I think it puts Dr. AROKE's continued practice of medicine at risk. But again, accepting everything that you said, Justice Blake, we're talking about events that happened 16 years ago, and under the HIS
That's
case.
not lost on me at all. I'm trying to think about if the board was to reinstate him with requirements of doing A, B, and C, A, B, and C conditions to keep his license. He doesn't have a history of showing that he can consistently comply with those. And that troubles me.
There are two instances in the past when he did not comply with that recommendation and then requirement. You are
After being advised of the sexual misconduct.
after being investigated for it, yes.
Can I ask you about the standards? You suggested that we should set forth some standards for the Board of Registration of Medicine.
If you could just keep your voice up.
Of course. You suggested that at the beginning that we should be making some standards for the board and for other boards. And so, one of the standards that you suggest is that we should superimpose the standards for lawyers on the standards for doctors. Is that your citation to Cappiello, I think?
What I'm arguing is that the standards in the HIS case should apply equally to doctors and lawyers. The standards are general standards about our system of justice. The idea that there is no misconduct, that, first of all, the standard protection of the public is the same for both the bar and the medical field, and I go into some detail in my brief about why the two standards are the same. I compare them. But certainly there is no reason that the standards in the HIS case should not apply to other licensees, because those standards that redemption is possible, and how Justice Toro goes into this long explanation that somebody who makes a mistake that it's fundamental to our system of justice that people can reform, and that someone who sincerely believes that he or she has not committed misconduct should not be required to lie. That is a general statement of policy that should apply to all human endeavors, all different licensees. And I don't think my sister in her brief disagreed that HIS applies to this case. If you read her brief, she basically tries to distinguish it, but I don't think she denies that the HIS standards apply.
But doesn't HIS apply specifically to a permanent decision, a bar, an infinite bar to reinstatement, which is not what the board is necessarily deciding here, correct?
I'm sorry.
HIS speaks in terms of a permanent bar. If I'm reading it correctly, it says that the seriousness of the offense and a failure to take responsibility cannot be used as a permanent bar.
That's true.
And in this case, the board was not making a decision explicitly anyway about a permanent bar. Dr. AROKE would have the opportunity to return and seek reinstatement at regular intervals, notwithstanding the board's decision. Is that correct?
That's correct. I suppose as long as he's alive, he still has a chance to come back to them. But if you look at the proofs of good conduct, which are ample in his petition, and the glowing letters of recommendation, what more could he do 2 years from now when he applies again, other than saying, I admit now that I did it, that would satisfy the bar that his character then is better than it is now?
Well, one of the things that the board seems to hold against him, and I'd like you to respond to this, is that they characterize him as showing more concern for his own plight than for the plight of the victims. Is that a fair assessment? Is that unfair of them to do?
The board says in its decision that he does not show any concern for his victims. But again, that's just about repentance. If you didn't do something, then you didn't have a victim that you need to show concern for. Nothing happened to this person, as far as you know. So it's hard to show concern. What he has done is he has said, I recognize that legally I'm adjudicated to have done this. This is heinous. This is reprehensible. Nobody would do this. I mean, he recognizes the wrongfulness of the conduct.
But he likens his punishment to like somebody going to prison. I think that's the question Justice Massing was asking, is he putting his own, as he's described it, crushing blow and feeling like somebody going to prison ahead of recognizing what the victims may have felt as a result of the alleged conduct?
What you're quoting, Justice Blake, is a letter that someone wrote in support of him. He never said that.
Well, it was submitted on his behalf, no?
Yes, it was a letter. It was a letter from one of the 14 letters of recommendation.
And part of his petition for reinstatement. So I took it that he adopted that as his own. He didn't in any way suggest that he didn't feel that way. He submitted it as part of his packet, which he's entitled to do. I guess the question is, you know, if you're weighing the scales of justice, he's put a lot more on his side of the scale and failing to acknowledge remorse on the other side of the scale. I think that's the question, right? Isn't that an appropriate consideration for the board?
I think that if you are wrongfully accused of heinous misconduct, I mean, this is just terrible. I think you and prevented from performing the work that you've trained for and everything he's overcome in his life to get to this eminent position that he's in, and thrown down from that. I think you would feel bad about that. And it is hard, again, to express concern for people that you don't remember, but you know that you didn't do it. I mean, again, it's established that these things happen. But under his principles, if he really doesn't think that he did these things, then it is hard to feel concern for his victims if he didn't have any victims. In fact, there's no physical evidence that anything happened to either of these patients. I mean, we have their testimony.
That's not inconsistent with so many rape convictions, right? There's very rarely evidence, and there's very rarely a witness outside the victim themselves. So that's not new to Dr. AROKE.
That is absolutely true, and I'm not making a blanket statement about victims of sexual assault. I mean, I understand that problems of proof are tough in those cases, but what I am saying is that from his point of view, it is hard to show concern for victims that he doesn't believe were victimized. Certainly not by him, and as far as he knows.
Does the decision preclude him from continuing to conduct research?
It has not precluded him from continuing to conduct research at University of Rhode Island, where, as you see, he's excelled and become, you know, a leader. And I mean, the brief speaks for itself, what he's accomplished there.
Is he a licensed doctor in Rhode Island?
Excuse me?
Is he licensed in Rhode Island?
Is
he licensed in Rhode Island?
No. He's not doing medical work. He couldn't be. I mean, they would simply give effect to the Massachusetts.
It's reciprocity for Mass?
Yes. No, he's not doing any medical work. He's like his. He completely respects that he can't practice medicine. He's doing work in statistics and other fields, epidemiology.
I see your time has expired, but let me check with the panel.
Just one question. And usually when we ask people at the end, they say, "I'll rest on my brief." And I want to ask you to I'd like to hear your concluding argument and what do you want us to do?
What I would like you to do is order the board to reinstate Dr. AROKE under such conditions and under such restrictions as the board deems proper. He doesn't have to treat patients. He can't get...
Okay, I got it.
Yes.
I just want to be clear, because I think your client might be in the courtroom. We do not have the power to order the board to do anything, right? We're reviewing Justice Karp's decision. I just don't want anyone to be misinformed about what our role is. So with that, we'll hear from the Commonwealth.
Thank you.
Good morning, Your Honor, and may it please the Court, Assistant Attorney General Erin Fowler for the Board of Registration in Medicine. I would like to start by responding to my brother's comment, excuse me, that the Board's decision in this case is identical to the decision in Hiss. I think it's important to look specifically at the facts of Hiss and what exactly the Board said in that decision. So in the decision in Hiss, the Board was considering, as you know, reinstating a petitioner who had previously been convicted of perjury. That petitioner maintained his innocence, and the Board felt bound by its reading of a previous SJC decision, Matter of Keenan, which the Board took to say that good moral character is inconsistent, logically inconsistent, with maintaining your innocence for something that you've been convicted of in a criminal court. And the Board said that putting the petitioner's failure to repent aside, it would say that he had good moral character. It would say that he is unlikely to commit a crime similar to the one that he committed, and that readmission to the bar would likely have no adverse impact. So the Board made very explicit that it was relying exclusively on the petitioner's failure to repent based on its reading of the previous SJC decision, Keenan.
I have a question that's a little bit different than that, because
Yes.
I'm thinking about sort of in the context of DCF cases, right? We sometimes hear that in order to get their child back, they have to admit that they have perpetrated domestic violence, by way of example. And maybe because of Fifth Amendment issues, maybe for other issues, they don't. It's not lost on me, counsel, this has been a very long period of time. Mm-hmm. I understand counsel's reading of the Board's decision of, they seem to have placed a higher point value, if you will, if you're adding up points, on his lack of remorse. Is lack of remorse, even if that's an appropriate factor, is that essentially saying he didn't admit it? Are those the same thing?
I would say they're slightly different, though sometimes considered together.
Right, so how are they different?
So I would actually say the distinction is not so much between lack of remorse and failure to admit, but between lack of remorse, failure to admit, and then lack of insight. So I think that might be the distinction. I don't think there is as much of a distinction between lack of remorse and failure to admit. I certainly think, factually, you can imagine a situation where someone says, yes, I did that, no, I don't feel bad about it. Here, the plaintiff is saying, no, I did not do that, which necessarily means I don't feel bad about something that didn't happen.
Hypothetically, and this did not happen in this case, but hypothetically, if the doctor had been charged with these crimes and he had a Fifth Amendment right, could the Board have held that against him?
The plaintiff could have pled, and petitioners often do plead the Fifth before the Board in some of these licensing
Are you allowed
cases.
to draw the negative inference?
That's correct. Yes. And the plaintiff was not doing that here.
No, I understand that. I'm trying to figure out where that line is.
Right.
If the doctor says it didn't happen, which is what I understand counsel to be saying, and the Board has said it did happen, other than admitting that it happened, what is his path to getting his license back?
Right. So, as you noted in the argument earlier, the Board was very concerned about his lack of concern for the victims in this case. The petition focuses a lot on him, on how this is like a prison sentence, how he has 2 job offers that he needs, how this makes searching for a job more difficult. The insight that he shows into why sexual assaulting your patients is wrong is that, 1, it calls his competence into question, again, about him. 2, it calls the question, it damages the public confidence in the integrity of the medical profession, which is, again, sort of an abstract concept.
For how many years, though? Is it forever?
That he would be denied reinstatement for?
Well, I mean, you never get to the question that you were answering, which was, what's his path?
Right.
So his path would be to engage more seriously with the effects of his conduct on the victims, and also engage more seriously with with services that could address whether this specific issue of sexual assault. So if you look at the petition for reinstatement, he talks about some post-conduct youth services. I think that's sort of a broad term, and he talks about how he went to a 2-day probe program that discussed professional ethics and problem solving. There's no evidence in the record that would show what that program focused on. There's just a certificate that's attached as an exhibit saying
All right, so another hypothetical, because I'm really slicing thin here, but I'm trying to figure out the path. The doctor comes in and says, I didn't do this, but if these women feel that some way they were violated, I'm very sorry that they felt that way. I'm sorry for any role I may have played in making them feel this way, but I didn't do it.
Right.
So I didn't do it, but contrition.
Well, of course, I'm hesitant to sort of give a check.
I know you can't give me a thumbs up or a thumbs down, but do you understand the continuum? We're parsing words here in a way that even if the board did not act arbitrarily and capriciously, which is what we have to think about, I'm concerned that there's not the position the board is taking gives this doctor, in my view, no path unless he says, I did it. And that's what I'm trying to figure out. And that just seems wrong to me.
Mm-hmm. So you could imagine a circumstance in which the doctor says, I didn't do this, but I have multiple patients leaving my office saying that, feeling that they were sexually assaulted by me. That shows that there's some sort of problem in my care that I need to take responsibility for, because ultimately I am responsible for the patient experience in my care. So I could learn more about how my actions might have caused them to feel that way without saying, yes, I did that. I can disagree about what happened and still acknowledge that that was the patient experience, and that's pretty rare. So.
Pretty what?
Rare.
Rare.
I would say there's not. I'll retract that. I can't make a statement about the commonality of sexual assault allegations.
I questioned Attorney Rose, is it Rosen? Yeah, about this and about what you just said, showing a lack of concern for the victim. But he answered correctly that those weren't Dr. Aroke's words. That was Dr. Leakey's words. That was Attorney Rosen's words. Is the board sort of holding against the doctor the words of his client and his supporters?
So what specific words are you referencing? I'm sorry.
There's the thing about he's it was like a prison sentence. That's not him talking. And in fact, the blaming the victim stuff, that's not him talking either. That's his lawyer talking.
Well, I think he's certainly imagined or expected to speak through his attorney. I also
but the board says that he shows no contrition. Is that really, can you infer that from the presentation of the lawyer?
I think you can certainly infer that from the petition for reinstatement, which was made on behalf of the client. We can imagine that, we can assume that the client passed or checked off on everything that was included in the petition for reinstatement through consultation with his attorney. I don't think it would be necessarily fair for us to imagine that there's some sort of contrition out there that is not in the record.
He does appear at a hearing, right? And basically he says, he apologized. It's very short. He apologized. He opens himself for questions. There's no questions. I mean, so did the board really look into his contrition?
I think the board made the determination about contrition based on the totality of the factors as it shows up in his petition for reinstatement, as it showed up in his transcript, and it also looked at how in the petition for reinstatement he continues to try to discredit the victims, which in itself seems to be a lack of contrition for the victims. If he's still...
That's his lawyer.
Well, I would disagree respectfully, Judge Massing. I believe it's the petitioner acting through his lawyer as made...
Agent-principal relationship.
Correct.
The agent speaks for the principal.
Yes, correct.
Could I ask on a different line? Understanding that we've been talking about the possibility that the board pulled some negative references or inferences about your client from the supporting letters, specifically the feeling as though there was a comparable to prison. That information, it seems to me, didn't come exclusively from the letters themselves. Would you agree with me with that?
Correct.
And is it the board's obligation to consider all of the submissions that were made in order to avoid the arbitrary and capricious standard? Does it have to consider at least everything?
It would It could consider, but it could also reject the relevancy of the exhibits. So I think that the board is under obligation to read and consider all of the evidence, but the board, and this came up in HIS, where a lot of the letters didn't acknowledge that the plaintiff ever committed any serious wrongdoing. They said that they were shocked by the allegations. This came up in HIS, that the board wasn't entitled to, or wasn't required to credit those letters.
I can accept. My question, I think, is a little bit different in the end, and that is, how do we know from the board's decision that they considered any of the supporting letters here? And if they didn't, what's the implication of that?
So the board is not necessarily, I think as your question acknowledges, the board isn't necessarily required to say exactly everything that it considered, and we can assume from sort of a totality of the circumstances analysis that the board considered the supporting letters, and that, so there's a case, Fish, that's cited in our brief, and in that case there's a similar issue where it didn't look like the board, the licensing authority, it didn't explicitly consider all of the mitigating factors in its decision, and there the court said, the board does not need to list out everything it considered, as long as it's pretty clear from the decision that those things were considered. Pretty clear it wasn't the exact wording that they used. And they noted in a footnote, yes, it would be better for the board in its decision to say everything that it considered, although it didn't say that that was required. So in that case, it looked specifically at the fact that the board had considered other mitigating factors as evidence that the board looked at the other mitigating factors that the plaintiff said that the board didn't consider. So I'd say that's probably the closest analogous case we have to here, where you can look at the decision. We know that the board obviously read the petition for reinstatement, that the board referenced in its decision one potential sort of, I wouldn't call it exactly a mitigating factor, but one argument an argument in favor of the plaintiff, which is that his skills are needed during COVID.
Came from places other than those supporting letters as well, right? That was a theme through the presentation. And in this case, there was a pretty clear directive from Judge Karp that the board on remand needed to consider glaring isn't the word that Judge Karp used, but some compelling, potentially, evidence in favor of Dr. AROKE and didn't. And still, in the board's second iteration of its opinion, it doesn't make any reference, explicitly anyway, to any of those letters or any of those supporting affidavits. Is that correct?
That's correct. And I agree that it would have been better for the court to specifically acknowledge those. I think I would point to the Fish case that says it's not required to explicitly acknowledge all of the evidence and factors, though I agree it would have been better, but.
If we reach the conclusion that it didn't consider those things, what do we do then?
If you were to reach the conclusion that the board did not consider those, I think you could still affirm the Superior Court's decision, essentially on the grounds that the court's task was to examine whether or not, or the board's task was to examine whether or not reinstatement of the petitioner would be in the public interest, or it would advance the public interest. And I think they properly considered all of the relevant evidence there. A lot of the information contained in the character references, don't have as strong a value because a lot of the letters don't acknowledge that he committed any serious misconduct and don't address his rehabilitation since the finding of license revocation. They also talk a lot about his professional accomplishments, how he acts towards his colleagues. I would argue that that's not necessarily relevant to the question of whether or not he's rehabilitated from these findings of serious sexual misconduct. One can be a really great researcher, a great scholar, a great colleague, and still have sexually assaulted patients.
Can I ask you a question before did you just do that? Yeah, you answered. Are we reviewing, are we reviewing the Superior Court or are we reviewing the board? Is it de novo or do we give deference to the Superior?
So it's a bit complicated because you would be affirming or reversing the decision of the Superior Court, but there's no deference owed to the Superior Court's determination. Okay. So you'd be looking to the board's determination. And
do we have the power to order the Superior Court to order the board to reinstate, or is that going? This is an action for cert, right? For certiorari.
Correct.
And what are the remedies that are possible?
I'm not completely sure, but I believe it would be a remand for the Superior Court for proceedings consistent with the opinion that you give.
That's very vague, but often
Sorry.
we resort to that.
Thank
you
you.
very much. Counsel, thank you both. You did a wonderful job on behalf of your clients. The matter will have been deemed submitted. Thank you. Going to hear one more case before the morning recess, and that is John Doe 523873 versus the Sex Offender Registry Board, docket number 22P555. As counsel sets up, just a reminder that this matter is impounded, so please do not use any names. Good morning, Mr. Coase.
Good morning. May it please the Court, Matthew Coase here on behalf of John Doe 523873. I'll refer to him as Mr. Doe from here on out. Mr. Doe's classification as a level 3 high-risk sex offender should be vacated, and his case should be remanded to the Sex Offender Registry Board for a new classification hearing. First and foremost, the hearing examiner committed error in this case by applying the high-risk factor for repetitive and compulsive behavior. There was no factual or legal basis for doing so on this record. The alleged prior sexual misconduct of Mr. Doe is not a statutorily defined sex offense, and there was no evidence in the record that soliciting a prostitute in the distant past was predictive of future contact sex offenses.
Is that because it was continued without a finding as opposed to a guilty finding, or just sexual conduct for a fee in general you say can't serve as a predicate offense?
Yes, as a matter of law. So Chapter 6, Section 178C sets forth 3 definitions. One of those definitions is for sex offenses. And then within those definitions, it says any convictions under, and then it gives a list of, probably 50 different statutes which require registration. So long story short, no. Sexual conduct for a fee is not a registrable sex offense. So whether it was a continuation without a finding or a guilty finding or a guilty verdict after a jury trial, that alone did not trigger registration obligations.
Where do we find the support for the fact that sexual misconduct must be defined to mean only an enumerated sex offense?
Well, I think it comes within the statute itself. So we look at legislative intent, and the whole purpose of the Sex Offender Registry statute is to warn the public of future sex offenses. As the Supreme Judicial Court has said, past is prologue. So in their wisdom, the legislature determined that these particular sex offenses needed registration in order to protect the public. So I would suggest that the converse is also true. In its wisdom, it left out certain offenses, and we can only assume that those offenses were not registerable offenses because they're not predictive of future sexual offenses.
So the board could consider it, but not as a factor 2?
Well, the argument that I'm making is I think that the board can kind of consider whatever it...
I mean, sometimes they consider armed robberies, right? Just in terms of compliance with norms and rules in our society. So you're not saying the board can't consider sexual conduct for a fee, but that it is not a predicate offense under factor 2? Precisely,
Your Honor.
Okay.
So as the court knows, factor 2 is what I consider in a state of erosion.
Call it the Judge Wilkins factor now, right?
It is Judge Wilkins, yes. So, and I think it is worth pointing out, too, that this hearing examiner's decision came out about 10 days prior to Judge Wilkins' decision. So the hearing examiner really didn't have kind of the guidance of Judge Wilkins. And
so, as I understand, and I'm happy to ask Mr. Shanai this, but my understanding is that the department did not challenge that, and they've sort of taken a relook at factor 2. So was there a request in this case to remand because it was pre-Judge Wilkins and pre-Sorb's sort of change of policy on factor 2?
Honestly, Your Honor, I don't think that was raised either at the Superior Court level. But I do think that...
You think this was 10 days, the hearing examiner's decision was 10 days or so before the Judge Wilkins decision?
That's correct, Your Honor.
We still have the aspect here of being caught in the act of sexual misconduct, and being caught in the act, in fact, getting a cough, which means you have to be good for a year, and then 13 years later, offending again.
Correct, Your Honor. But the point I was trying to make is there has to be it has to be tethered to some sort of scientific principle in this case. If we just kind of go by the common sense of, this offense says sex in it, and we're dealing with Sex Offender Registry Board, I don't think that kind of connects the two. I think it has to be predictive of, future sex offense.
Can I just ask about the state of the record, though? I don't think the sexual misconduct argument is necessarily, I don't think it's necessary for your factor 2 argument. It's part of your factor 2 argument, but I think you can still make the argument that factor 2 shouldn't apply. But the argument that the term sexual misconduct is vague, that's actually being made for the first time in this appeal, right?
No, I disagree. I think that there is...
Specific argument that the words sexual misconduct are vague?
I believe that in the Superior Court, the previous attorney says alleged sexual misconduct.
Supposed sexual misconduct.
Supposed misconduct. So I agree it's not a full-fledged attack on making a vagueness argument, but I do think that that argument is kind of part and parcel of what counsel was arguing in the Superior Court.
Well, but according to your reply brief at page 6, you say, Doe challenged the hearing examiner's use of the 2001 incident as supposed sexual conduct, which, to Judge Massing's point, is different than saying sexual misconduct is constitutionally vague.
Well, I think, as Justice Massing was saying, I think I can still be victorious on this point, even moving beyond the vagueness argument. Because I think there's also a factual argument that needs to be made here. You have to look at Dr. Plodd's testimony and his expert report. So Dr. Plodd was asked this question point blank on direct examination, and I think Dr. Plodd answered the question quite unequivocally that this is not the type of conduct that people in this field of research consider to be predictive of future contact sex offenses.
Do we have a case where the Static 99 was held to either pass a Daubert-Lanigan or was part of the basis of reversing the Sorb's decision?
Not that I'm aware of, Your Honor. And I'm not suggesting that, this whole case is tied to the Static 99, because I don't. I think what the Static 99 is, it informs Dr. Plodd's opinion. I understand that there was clinicians at the treatment center that came to a different conclusion on the Static 99.
Because Plodd said he would be a level 2? Or moderate risk?
Yeah, he said it was moderate risk. I think in his words, he said he was closer to a level 2 than a level 1, if I'm not mistaken. But more to the point, back to the point regarding Dr. Plodd's testimony, I think it's also telling that, the board counsel did not argue that factor 2 was applicable here as well. And then also with respect to factor 2, I did want to bring up the point about compulsion as well. This is another area that's been litigated rather thoroughly in our world. But I think that this case is distinguishable from the Doe 6729 case. And I think one of the things that the SJC pointed to at that page 767, it talked about proximity in time. So when you look at kind of the common real-world definition of compulsion, it's basically an irresistible urge to act in a particular way. And I think if you look at the conduct in this case, sexual conduct for a fee in 2001 and in 2014, which, a very heinous, sex offense. We're not standing up here defending the guy. But there's really no similarities in the conduct whatsoever, and there's really no proximity in time. We've got about 13 years difference in time. So I think it would strain credibility on all fronts to argue that this guy was acting under an irresistible urge to conduct himself in a particular way.
Can I ask you about just a factual issue about the index crime? In your brief, you say on page 7 that that the victim she got into a white minivan driven by Doe, believing the vehicle was a taxi cab. Was that a mistaken belief, or was the vehicle a taxi cab?
I know that Mr. Doe did have a taxi license and worked as a taxi cab driver for a long time. My recollection was that the Boston police report had made a statement, something to the effect that maybe he was working off hours. In my experience, sometimes taxi drivers work, Uber or Lyft or something like that. So
the vehicle would appeared to be a taxi cab.
I would say so, Your Honor.
So this is, the board's duty to protect the public. This is like the nightmare crime, right? The taxi cab driver who rapes the drunk female who gets in.
Your Honor, I think that the board's position, or the board's duty under these circumstances is not just to look specifically at the horrificness of the crime, which I readily admit is a horrific crime. It's to take more of a holistic look, apply the risk factors, balance those two, and then make a determination based upon that. And I think in this particular case, this is a strong case where you could argue that balancing was done incorrectly. I think in this particular case, you had an expert witness who gave an uncontroverted opinion that Mr. Doe was somewhere between a level 1 and a level 2.
Well, in terms of Plowd there, the hearing examiner says, by and large, I agree with Dr. Plowd's application of the factors, and where they part, but his classification decision can't be what governs, right? The hearing examiner has to make the classification decision, and she says, I apply the factors differently.
Right. So that was two different arguments that I made, Your Honor. So I did make an argument, I believe it was the second argument in the brief, was that the reasons that the hearing examiner discounted Dr. Plow's testimony was objectively unreasonable. I was actually talking more about the balancing and weighing of the different factors. If it's okay, if it pleases the court, I'll finish that argument, and then I'll go back to talking about the discounting of Dr. Plowd. But as I was saying before, we have the expert evidence, which was based upon evaluative testing. We had 4 out of the 7 risk mitigating factors. We had probation, advanced age, participation in sex offender treatment, home situation and supports. There's what I consider a dearth of high-risk factors in this case. The only one that the hearing examiner found was factor 2. And I kind of liken this to, a criminal case where the the Commonwealth needs to meet its burden of proof, and I would suggest where there's a case where there's about maybe a half of a high-risk factor, they haven't met its burden of proof of a level 3. And then what I consider to be kind of the checklist approach to the remaining risk factors. 5 out of the 7 risk factors are checked off merely because they all come out of the governing offense. Certainly they can be taken into account, but I think it kind of tips the scales when all of the risk factors basically come from one particular event. I see I have a couple seconds left, so if I could go back and address your question, Justice Massing, about Dr. Plod. So as I was mentioning before, the law clearly states that the hearing examiner is not required to accept the experts, but they have to give adequately objective reasoning for rejecting that opinion. And what I was saying in this particular case is, again, it goes back to what I consider the checklist approach. This particular hearing examiner said, I disagree with Dr. Plod because I checked off 3 or 4 more boxes than he did. And I would suggest that that's unreasonable under the circumstances.
Just checking. Thank you very much. Attorney Shanai?
If it pleases the court, David Shanai for the board. The question about the static 99, no case has ever been premised on the acceptance or not acceptance of the static 99, because even Dr. Plowd and all experts agree, the static 99, when it's used, is not dispositive of the issue of risk. What it is they start with that as their baseline, and then in this case, Dr. Plowd looked for positive dynamic factors that he says lowers the individual's risk. The board, even taking into mind the static 99, felt that there were factors that static 99 didn't cover which actually increased his risk, such as the fact that the individual was an extra vulnerable individual and that violence was used during the sexual assault, and that the sexual assault, which the static 99 does not cover, included penetration of the victim. And finally, the hearing examiner also felt that there was a repetitive and compulsive component, which neither Dr. Plowd accepted nor did the static 99. So I think the difference is Dr. Plowd found all positive factors he says reduced and didn't look at these factors the hearing examiner felt increased the risk.
Does the board consider the fact that after the rape he used her debit card and made purchases?
I'm not sure that how much that came into account in the hearing examiner's decision, because the hearing examiner talked about it but didn't really discuss it further than these events occurred. So I can't absolutely say, yes, the hearing examiner also considered that as negative information. I think it is negative information. It may be presumed the hearing examiner may have considered the fact that the hearing examiner wrote about it, but never specifically referenced it in the discussion session. As
if we excised the consideration of the sexual conduct of a fee from this hearing examiner's decision, does it still support a level 3?
I think I put in my brief that it does, and I think it's because this occurred 7 years prior to the classification hearing, and it's a heinous sex offense. More importantly, the individual was still incarcerated at the time. Now, he's making progress. Yeah, I mean, we can't, and the hearing examiner acknowledges that he's making progress. But the hearing examiner didn't find that progress overrode this individual's sex offense for the 7 years that it occurred where he's been incarcerated. And I think the hearing examiner refers to the fact that, even though he credits him for his future probation and credits him for gives him moderate credit that he's participating in sex offender treatment, the individual is only 47 years old, and the hearing examiner did give him credit that, but he's only 47. He hasn't reached the age where his risk would be substantially reduced. And the hearing examiner gave him credit for a support system. But then it becomes, when he gets out, are there enough checks and balances in place to show that he is actually, at this point, going to progress and reintegrate into society properly and without any problems? You know, this, again, it's hard to get over the heinous nature of this sex offense and the way it occurred and the recency between that and the hearing examiner's classification, hearing, and decision. And I just don't know how you get around that.
When is he eligible for a review of his classification?
It'd be April, would be when he could apply for a reclassification.
2024.
Right.
What about the, factor two? I mean, this is a pretty weak factor two, wouldn't you say?
Well, you know, I think Doe 6927, Justice Kafka resolved this issue. And he basically said, look, in the affidavit I submitted for that hearing from Dr. Hansen, Justice Kafka said, look, if someone's investigated by an authority for an act of sexual misconduct or is convicted of a sex offense and then commits a new offense, it's clear that having gone through the system one time before is not a deterrence. And that is the part that's the compulsive nature. That having gone through the whole system, and this individual on that charge not only was charged, but admitted to facts sufficient to warrant finding a guilty and was put on probation for a year. So he knows the ramifications of committing an illegal sex act and still yet does it again. And that's the compulsive nature, and that's what Justice Kafka focused on.
I mean, it's compulsive 12 years later? That's...
You know, time may change that. Justice Kafka, that was discussed when we argued that case, because again, there was distance in time. Justice Kafka didn't focus on that.
What was the distance of time in 6927?
I want to say it was at least 10 years. And I think that part of the argument was that it's such a distance in time, but Justice Kafka didn't address that issue. He focused primarily on the fact that the individual went through the system once, knew the ramifications of committing what happens when you commit a sex offense, and then does it again, showing that there's no deterrence, that the criminal justice system is not a deterrence to this individual for committing a second sex offense.
I probably am wrong about this, but I thought that after the department decided not to challenge Judge Wilkins' order, there was a host of remands to reconsider without factor two. And this on the timeline would fall into that. Am I not remembering that correctly?
Actually, there were a number initially, and then we went forward arguing harmless error. Then Doe 22188 came down and changed the standard. But this case here would again fit within the Doe 22188 standard if you took out factor two, because the remaining factors are sufficient to warrant the level three. I mean, you get to the point where the second part of the 22188 analysis is if the factor was misapplied, the second factor is, do the facts support the classification decision? Do they clearly dictate the classification decision? If they don't, then you go to the third factor, which is whether or not the factor itself, the misapplied factor, if that factor may have possibly affected the decision. We're saying in this case it would be stopped at the second part of that analysis because the facts clearly dictate the warrants the level three classification of this matter, even without considering factor two. And I think I had one more scheduled this week that is a misapplied factor two. I have one brief pending with that same issue, and I'm hoping those are the last two I ever have to do for the rest of my career. Although, knowing the board, who knows? I may have to argue it another time on a new case.
We won't hold you to that.
But, you know, I think I've covered these issues really well in my brief, unless there's specific questions.
Specific question. I mean, it's putting aside the question of waiver. it seems that the board's choice of the word sexual misconduct in a few times throughout the regs is intent. I mean, I think we have to, as a matter of legislative intent, we have to consider that was intentional, that they knew how to use the word sex offense when they meant sex offense. And so sexual misconduct is meant to be something broader.
Correct.
Is that scientifically sound?
I don't know that it's scientifically sound because I don't do the science part of this or make the regulations. I basically just defend hearing examiners' decisions on these matters. But I think there's two cases that are interesting, and I thought of it overnight. I was thinking about different things. In 2012, and I think I got it's Doe 16748. The board at that time had the reclassification regulation where the board could reclassify, and one of the things they could reclassify on was acts of sexual misconduct. And the court in that case said that the board could only reclassify if someone was convicted of a sex offense because the legislature never gave them the authority to create this reclassification issue, reclassification regulation. The board
To
then...
reclass them up based on it?
Right.
Okay.
And what happened is the legislature then put in the reclassification regulation that the board had verbatim. And so now the board can investigate or can go up if an individual has been investigated for an act of sexual misconduct. Now, Doe 3177 didn't directly address the issue of differences between sexual misconduct and sexual offense, but they did say that the board has the authority to reclassify an individual if an individual has been investigated for a sex offense in which he has not been convicted, and that the standard for the board to go forward is if the evidence proves by a preponderance of the evidence that the individual, yes, indeed, committed this offense that he's being investigated for. Now, they didn't go into details about whether it had to be a enumerated sex offense or whether it was an act of sexual misconduct, because in that case, it was actually a charge of rape, I believe. But again, I think those two cases kind of show, they don't specifically hit the issue of definition, but they kind of show that the court at least was looking at this in the realm of the differences between acts of sexual misconduct and sex offenses.
I get the 16748 was the one, and then
the site on that is 82 Mass Appeal 152, and if I remember right, that was a Justice Kafka decision, and the Doe 3177 is 486 Mass 749, and I forget who actually issued that decision. But I think
let's
those...
say that it was the SJC.
Yeah. But again, I think that's really the board's position on that, is that there are two different concepts and that the board looks at sexual misconduct as acts of sexual misconduct that do not become convictions, and that it doesn't necessarily have to be an enumerated sex offense. I mean, for a good analogy would be the open and gross and lewd and lascivious behavior. You need two of those to make it an enumerated, but you only need one of those if you want to reclassify somebody upwards, if the board wanted to. And I think that's a good example, because if it's only one, it's an act of sexual misconduct. And if he's convicted of two, now you've got an enumerated sex offense. And I think that's kind of a good analogy of the differences.
Yes and no, because I mean, because they didn't make the same thing with the soliciting sex for money, whatever that crime was.
Right, that's not enumerated, but committing an open and gross and lewd and lascivious is not an enumerated until you have the second one.
Yeah.
So unless there's any other specific questions, now I'm ready to rest.
I don't see any. Gentlemen, thank you both. The matter's under advisement.
Thank you, Your Honor.
We are going to take the morning recess. I just want to check in with counsel on cases 4 and 5, that we're going to call them together. The appellant will have 30 minutes, and each appellee will have 15 minutes. Is everybody on board with that idea? Great. All right. We'll be back shortly. Thank you. Okay. Good, oh, it's still morning, okay, good morning.
Morning.
So for the record, we are calling together John Jenkins and others versus RHINO Capital Advisors and others, 22P 1026, and I apologize in advance for mispronouncing this. SUSAN Aukstikalnis and others versus member of the Lakeville Planning Board and others, docket number 22P 1024. We've all agreed that these cases have been paired for purposes of argument. The appellants will have 30 minutes, and each appellee will have 15 minutes. So with that, Attorney Bobrowski, when you're ready.
Well, you're not required to use all your time.
Thank you. Good morning, Your Honor. My name is Mark Bobrowski. My office is in Concord. I represent the private appellant, RHINO Capital, in this case. And for the purposes of just setting up what I'd like to do, the argument on statutory construction in my brief is the same in both briefs. So I'll cover that concurrently, if you will, with regard to both cases. There's some slight differences in what my brothers had to say when it was their turn to offer statutory construction tools, and I'll address those separately. I'll come back to talk about the floating zone. I'll conclude, and I don't expect that this will take more than 20 minutes, except if you have a lot of questions.
Before you start that, can I just be sure you are not contesting standing for either set of appellees?
That's correct.
And do you agree with the trial court's assessment of why each neighborhood group has standing?
No, but I didn't appeal it.
But you're not contesting it, okay.
I'm, well aware of the standard in the Marashlian case on clearly erroneous. I thought it was better to just focus on the efficacy of the DOD district. So let me give you a bit of background about where we are and why this is important. In 2012, the voters of Lakeville at town meeting adopted both Article 26 and Article 27. At the time, and still today, there is a derelict state hospital, Lakeville State Hospital. I would call its conditions horrific, but I'll let my brothers try to pretty it up. I don't think you can. It's just an eyesore. It's been an eyesore for decades, and it's not going away anytime soon. So, and I think it's dangerous to be on the property. It's that bad. So with that context, in 2012, the voters of Lakeville passed Article 26, which was an acceptance of Chapter 43D of the general laws, also called the Expedited Permitting Act. And that law came into place so that municipalities could designate priority development sites for special treatment under the Expedited Permitting Act that would hustle the permitting along. There were various provisions of both the regs adopted in the CMRs for expedited permitting and in the statute itself. Was there a permit pending at that time? No, they couldn't do anything until they accepted the provisions, and that was Article 26. There was no.
So that's Article 26 was anticipating a future application to be filed.
Yes, and I think that's the connection to Article 27, because the Expedited Permitting Act is just an acceptance of the statutory provisions. It's not setting up the zoning that would be expedited in order to accomplish the priority development project.
Right. One of the briefs on the other side argues that it was actually that Article 26 was intended to fast track an application under the mixed use development district. Is that factually correct?
I don't know that that's the case, so that's news to me. All I know is that the acceptance of Article 26, which was expedited permitting, specifically named 43 Main Street, which is the subject property for today's discussion, as a priority development site. So
you're suggesting a connection then between that action and the next Article 27 creating the DOD?
Yes.
And so, so they created the DOD specifically for that property, is what you're saying?
It seems like it to me, because it was the planning board that sponsored the Article 26 measure, and it was the planning board that sponsored the DOD. So
isn't that like spot zoning? Is that allowed?
It's a 49-acre site. It's not spot zoning under any case in the history of Massachusetts spot zoning cases.
And it's specifically changing the zoning law for one particular property?
Well, it didn't, in my opinion, it didn't change the zoning for that one piece of property. It created a town-wide overlay district, and certain properties within that district, namely those with 25 acres, were eligible to take advantage of the benefits offered by the DOD.
So does that mean that, with that interpretation, I really need to break it down a little bit, that the town intended to apply the DOD to all land
Yes.
in the town?
But the only properties that can take advantage of it are those that have 25 or more acres. This is a relatively common
That's
tool.
what confuses me, right? Why enact something that applies to all the land? Why not just enact something that applies to the specific area that, if, for example, in your case, you're looking to put the warehouse on?
I can't answer for the 2012 town meeting.
Is it poor draftsmanship?
I believe it's really poor draftsmanship, but that's not beside the point. We're stuck with it. I know that at various other times, the Lakeville voters have faced a quandary regarding the Country Club, which is not the same property as 43 Main Street, and there may have been others. But I think what they were intending to do is use a very common tool, which is to set eligible parcel size within a designated district. For example, in many towns, we have cluster zoning, and it's usually available in the residence agricultural district. And there would be a designation that no parcel under 5 or 10 acres in many towns can take advantage of it. They're not little districts, they're just eligible parcels. The same rule of thumb would apply here to the DOD. It's town-wide, and I'll get to my rationale for that in a second. And the 25-acre parcels within the townwide district are eligible parcels, not little sub-districts, just eligible parcels.
So then is it your position that because we're to interpret that the town intended to apply the DOD to all of the land in town, that the map does not then need to be amended?
No, there's no map amendment for the floodplain overlay district. There's no map amendment for the water resources overlay protection district. There's no map for whatever that I know of.
But do those districts
They're
include
townwide.
the entire town?
Yes, and Judge Spicer uses them as examples when he says that the town knows how to create a townwide overlay district, and they chose not to do so in this case. And that's my fundamental argument with the land court's decision.
What do we do with the affidavit that was provided from James Murat, if I'm pronouncing his name correctly, that seems to say that what was contemplated was exactly that, was an amendment of the zoning map?
Well, I'm well aware of the affidavit, and I addressed it in my brief by citing to Sutherland statutory construction that the view of the drafter, well, it may be interesting reading, is not dispositive as to the intent of the 57 people who voted for this. He's just one person. I don't even know if he voted for it. But it is the intent of the 57 who voted positively at the 2012 town meeting that we're looking for, not Mr. Moreau's opinion. And I think I cited to 2A Sutherland statutory construction 48:12, 7th edition. I'll just read what Sutherland has to say. The United States judiciary recognizes that the correlation necessarily exists between what a statute's drafter understands the bill to mean and what the enacting legislature understands to mean. As in England, American courts typically use the touchstone of legislative intent to guide interpretation. For these reasons, courts generally do not look to the drafter's view or understanding of a statute for assistance in interpreting the law. And that's a direct quote from Sutherland. So,
quick question on the record here. On that affidavit, as I read the record, it was submitted after arguments in a supplemental motion that was denied?
I don't know if it was denied. Mr. Maurizio and I had a conversation about it. I don't think we objected to it, so we included it when we prepared the appendix.
Okay.
I know you know this, but I need to continue to go back to basics here.
Okay.
Okay, so as I understand the purpose clause of the DOD, and I know you spent a lot of time on the last sentence of it, but I want to ask you about some other sentences. One of which says, the purpose of the Development Opportunities District is to authorize the innovative use of, my emphasis, certain portions of a defined overlay district for activities, et cetera, et cetera. How do I reconcile your argument with the portion of the purpose clause that talks about certain portions and a defined overlay district?
Easily. The certain portions are the 25-acre eligible parcels, and the defined overlay district is the townwide DOD.
How can it be certain portions if it applies to the entire town?
No, it's the certain portions references to the 25-acre parcels that are within the DOD. So I'm looking for the sentence. I have it here. Yes, the innovative use of certain portions of a defined overlay district. The certain portions would be those 25 acres within the defined overlay district, which is a townwide overlay district.
So then one of the next sentences says, the intent of the Development Opportunities District is to provide opportunities for economic development expansion in a planned multi-use district while protecting the natural resources of the town.
Yes.
That seems to me to militate against the view that's intended to apply to all the land in the town.
I think the key is in the last sentence, which we've been avoiding.
Well, I know that. Your brief says that. I want to ask you about the other sentences.
I don't think there's anything in that sentence that indicates anything other than what it says, the intent of the DOD.
Except that it differentiates between the planned multi-use district with the goal of preserving natural resources. So those two goals, how do you accomplish those if the DOT applies to all land in the town? Because that would mean you could put a warehouse anywhere.
Again, if there's multiple opportunities under the DOD because there are multiple 25-acre parcels, that would be the planned effort to take advantage of the DOD townwide.
So the parcel at issue here, do you think that you could put a manufacturing plant there?
The proposal was to put a warehouse distribution facility.
So could you put a public service facility there? Could you put a wholesale distribution center?
Well,
Could
if
you
you
put
look-
a medical center?
The uses in the DO district that are available are listed in section 7921, and they are manufacturing and industrial, high technology activities, warehouses, distribution centers, municipal public service facilities, transportation terminal, hotel motel, research development, office building, medical center, trade or professional school, country club, retail, service, theaters, restaurants, and other places of public assembly. So it was intended to be a very flexible district, and it would be only by special permit on a 25-acre parcel. So the planning comes in coordinating these things as they begin to pop out of the woodwork over the 10, 15, 20 years of the adoption of the DOD. This was, I think, contemplated to be the first one because the place was literally falling apart. And the DOD is the next article, and 43 Main Street is designated in Article 26 as the only priority development site in Lakeville.
So hypothetically, if I agree with you that the language is ambiguous for purposes of this question, what else do we have in the record to suggest that the town intended that the DOD apply to the town in its entirety?
Well, I think that's the ultimate question for statutory construction. So I spent a good deal of my brief going into what happens when there's an argument about whether it is ambiguous or not. And on page 7 of my brief, I cite the ENGIE gas and LNG versus DPU. And the quote from the SJC here, just from 2016, I think is enormously important. The argument that you don't need to go on if you find the provision not to be ambiguous misapprehends the statutory interpretation. The court does not determine the plain meaning of a statute in isolation. Rather, it concludes that the statute is unambiguous only after considering the specific language of the statute and in the last sentence of the quote, the standard rules of statutory construction and grammar. So, what did the court do? The court said that there were a couple of rules of statutory construction that applied, but they were pretty bland and generic and didn't go into specific detail. When you look at the argument from the perspective of the standard rules of statutory construction, it involves the history of the subject matter involved, the end to be attained, the mischief to be remedied, and the purpose to be accomplished. Still other standard tools rely on extrinsic evidence from an act's legislative history or sequential drafts of legislation or look to intent. administrative interpretations to determine legislative intent. Courts may consider the title of a statute to determine legislative intent and the tenor and subject of the act.
Right,
The
so
land court did none of that.
Stay with the ambiguity theme for a minute. And so now I'm going to look to sort of some extrinsic evidence. The public hearing notice in this case said, quote, "A copy of the zoning map showing the location of the overlay district may be inspected at the office of the town clerk," end quote. Why do we need that?
Well, this is my brother Costa's argument. First of all, it has nothing to do with legislative intent or history. It's a document outside the chain of legislation. It's a
So the
form.
public hearing notice is irrelevant here.
It's irrelevant. It's irrelevant. It reminds me of Preston versus Board of Appeals of Hull. In that case, the case turned on Chapter 48, Section 6, Paragraph 4, which says that if the lot's separate and it's got 5,000 square feet and 50 feet of frontage, it's forever buildable as a single-family home. Mrs. Preston bought Lot A. Okay, that was fine. It was ready to go. It was protected. 2 weeks later, she bought Lot B. And because she owned both properties in common ownership, the court said they merged. In the argument at the appeals court, the Abstract Club, I think, raised the argument that in the legislation there was originally a provision that said that lots in common ownership adjacent to one another, non-conforming, merge. And it was not in the final version of the statute. So they said, how can Mrs. Preston only have one lot to build on instead of the two, which the statute seems to have anticipated, only to have that language fall out? And the court said, that was evidence of nothing. Evidence of nothing. And so it's pretty much the same situation here. The clerk or whoever prepared the notice did what they usually do. They published it in the newspaper. It references a map. There was no map. Away we go. It means nothing.
Going back to where you opened about 43D, do Article 26 or Article 27, other than being sequential, refer to each other at all?
No, only in the sense that Article 26 specifically makes 43 Main Street a priority development site.
So again, me and my hypotheticals, what if we were talking about Article 26 and Article 32? Does that change your argument?
I think it would be a weaker argument, but I would have to know more about the intent of the planning board in introducing the articles. I think that the sponsorship of the planning board back-to-back was a way to tell the voters that they could have some relief from Lakeville State Hospital if they, A, accepted Chapter 20, Article 26 for expedited permitting, and B, the DOD, because the next day, it's a townwide district, the next day, it's ready to go. There could be an application for a special permit. It didn't come for 8 years, at least from my client, but there could be an application for a special permit and they could reap the benefit of being a priority development site. So those are the things that we said in response to the quote I just read from the SJC. We actually looked at the legislative history, 26 and 27 back to back. There's nothing else that supports the intent of the voters, the 57 who did vote in favor of this, other than that, which I don't view as a coincidence. I think it was a deliberate placement of the articles back to back. And on the other side of the equation, the land court cites, it cites a couple of bland, to use the word of Sutherland statutory construction, provisions for statutory interpretation, which really don't apply.
Well, they might be bland, but it seems to me that your argument does not really address or perhaps reads out of the provision the words "those" of underlying district and "as shown" on the zoning map.
I disagree with that entirely. In fact, I want those words to be in the discussion because those are the very words that make Section 7.9.1's last sentence ambiguous.
So your criticism of the trial judge for focusing on those words were not that he shouldn't have considered them, but that those words in context support your argument.
Exactly. My argument is this. Town meeting is, I don't know where you reside, Justices, but I've been a land use lawyer for 38 years. I go to town meeting many times in the course of a year. And town meeting is a wonderful Norman Rockwell moment, but it's also chaotic and very unpredictable. So whereas the author of the floodplain overlay district said that it's a townwide district in a certain way, and the author of the Water Resources Protection District said it in a certain way, they probably weren't the same people, and then years later you have somebody trying to do the DOD, and he or she, we don't know who, basically botches it. I mean, that's essentially what happened here. That's my take on what happened.
Are we supposed to just ignore the words as shown on the zoning map?
No,
or
no.
interpret as shown on the zoning map to mean what?
Well, I think they can be read one of two ways. So the first way that I would read them is to suggest, as did Judge Speicher, that the words as shown as, I had a page on this somewhere here, that the words as shown as
shown on
this, well, I think, I have to get the words in front of me, just hang on, okay. The first way of interpreting this is that it's an overlay district superimposed over those underlying districts as shown on the zoning map. So it's only going to be superimposed over those underlying districts, and then the map itself will be as shown on the zoning map. So that reference refers to the DOD as being as shown on the zoning map, not to the underlying districts. My interpretation is that when you look at the floodplain overlay district or the groundwater resource district, it's basically just a couple of added words here that make it ambiguous. I think it means that the district is an overlay district superimposed over the underlying districts as shown on the zoning map. The underlying districts are all shown on the zoning map. The underlying districts are basically business, manufacturing, and residential. And when you reference it that way, it's over the entire town.
So instead of saying those, it's all.
That's what Judge Speicher says in a very convoluted paragraph, I think, with no citations whatsoever. It's just his grammatical preferences, and I think he misses the
But what you're
point.
saying is that that it doesn't mean those overlying, it means all districts on the map.
I think that those words were probably superfluous, but I think that they are important because they make this provision ambiguous.
Right, but going back to that bland law, we're not supposed to read, we're supposed to consider every word, none are superfluous.
But only in the context of legislative intent, not grammar.
So then if we have, going back to my questions about the purpose clause, another sentence from that is that the Development Opportunities District is an overlay district superimposed over those underlying districts as shown on the zoning map.
And the underlying districts are shown on the zoning map. That's where I come at this from.
So in the second case, which is Mr. Maurizio, there's a suggestion on page 12 that town meeting has voted to repeal this based on this case. I'm not sure if that we can consider that. Can we?
No, I don't think so.
But I was going to ask, as of July 28th, after Judge Speicher's ruling, was there any effort, I mean, the town could have then amended the zoning map, right? Or amended Article 27?
I haven't been following that closely. My understanding was that there was some interest in that. Town Council Amy Questle is sitting to my left, and perhaps she can answer the question.
If we decide, and I'm not asking you to agree with me, but if we were to decide that the intent of the DOD was to overlay specific districts that were not specified, this would be an affirm, right?
I'm trying to understand your question.
I guess I'm trying to get to the penultimate question, right? If we decide that the DOD intent was to overlay specific districts and those districts were not specified, this is an affirm.
Well, the underlying districts is a specific reference to those sometimes called Euclidean districts in the sense that they appear on the zoning map in virtually every city or town. It's hard to map an overlay district because some are resource dependent for boundaries. For example, the floodplain relies on FEMA mapping. Groundwater resources relies on surficial geology. Very hard to put that on the zoning map. When you do, it creates a contorted, confusing zoning map. So the three underlying districts here in the zoning bylaw of Lakeville are, I believe, residential, business, and manufacturing. I could look at the section in the bylaw, but I think that's my remembrance of it.
I mean, one way you could do it is the way they did it for the mixed-use development districts. They specify meets and bounds, and that at the end they say, this is on record, Appendix
I know.
299 to 101. At the end, they say this is 73.3 acres, which I think includes the Blakefield Hospital site, right?
I don't know about that district itself. But the point is that the author of this, did he intend to specify certain underlying districts and just failed to do so? Or did he intend to actually prepare a map
There's a
and
theory
just
that they
failed to do so?
intended, putting aside the affidavit, there's a theory that they intend to do it in two parts.
I have not ever seen that. I have never seen a municipality adopt the text of a zoning bylaw at meeting number 1 and then dust off their hands and say, well, we'll be back and we'll do the rest later. It's hard enough to get the first piece on the warrant in a small town and to get it through.
Practically speaking, doesn't Noonan speak about that sort of situation? So it's not the first time that it's ever happened. Am I correct about that, or am I missing the point?
I kind of missed the nub of the question.
Sorry, whether it happens frequently or not, isn't that the situation that Noonan speaks to?
Well, Judge Spicer cites the Sorrell versus Town of Natick case as an example. It doesn't have anything to do with what happened in Lakeville in 2012. In the Sorrell case, it's one of a kind. They put in a giant overlay district. I think you had to have 1 million plus square feet in order to be eligible to be in it. And they voted one guy's property in. The next town meeting, Sorrell came back and said, me too, I want to be in the same district. And the voters turned it down. And the quote from the case that Judge Spicer relied on, it's okay to do something at meeting number 1 and another thing at meeting number 2, is inapplicable in this case. My view...
Would your interpretation of the DOD cause some residential and other properties to essentially be rezoned?
Only if they're part of a 25-acre parcel. And they would not be rezoned, they would be eligible at that time. So it's designed to work both ways.
Eligible for what?
The benefits of the DOD townwide district. The special permit process, the new uses that are listed, the more flexible waiver
Hypothetically,
provisions.
a residential house in that 25 acres could then say, I want a special permit to put a warehouse where my house is.
Well, they'd have to be in conjunction with the other owners of the 24 acres around them, and they'd have to do it as a joint application. A single-family house lot would not be eligible for that.
And how many acres would this project cover?
49.
49.
So at the end of the day, I look at my choice in interpreting this, and your choice, I suppose, now as well. The key is the intent of the 57 who voted yes. 57 people. We'll never know. We're not going to take depositions to find out what they thought they were voting for. That's already been banned by the SJC in the Bellingham case involving a power plant vote years ago. So option number 1 is to follow the path that Judge Spicer has blazed and to suggest that the following sequence basically occurred. 1, the voters accepted 43D, expedited permitting. 2, the voters designated 43 Main Street a priority development site. 3, the voters approved the text of Article 27, the DOD, and then they stood back proud of their accomplishments and said, let's go home and we'll come back another night and we'll put that on the map. Like I said, I've never seen that happen before. The alternative is to say exactly what I just said. The voters accept 43, they designate 43 Main Street, they approve the DOD, and they assume their intent is that the DOD will now be available for use by the next person with 25 acres in the town who wants to apply for a special permit to do a priority development site.
And you were the next person. There's no other project.
No, it didn't come for 8 years. It did
it for 8 years?
You know, there may have been intervening projects that made use of this. I've heard a past reference to a Cisco project that pulled out.
Anything else that's bubbling around the surface here or at the SJC that we should know about? Is anyone else challenging this in this way?
No. I think those cases
You
are
try
long.
to be consistent.
They're long gone, yeah.
Okay.
Yeah. So I think ultimately that's the way I frame this. And knowing voters at town meeting like I do, I think I'm a pretty good read of them. I can't imagine them saying, oh, we'll come back another day. I think they thought it was a town-wide district. Just a couple of other points. I think we've covered the contributions to statutory construction of both of my brothers, and so I don't think I need to repeat myself on that. Just the floating zone topic, just to close it out. A floating zone is a district which is amended by administrative action rather than legislative action. So it would be it would be placement of a district on a map by the planning board instead of by the town meeting in a town or the city council in a city. If you take my interpretation to be correct, that the DOD is a town-wide district and that the 25-acre parcels are merely eligible parcels and not little sub-districts of some sort, there's no floating zone because the district was fixed by town meeting. There's no placement of it on the map by anybody other than town meeting. And the 25-acre parcels, once assembled, would just be eligible parcels for the benefits of the DOD provisions. And as I said, that's a common tool. It's used all the time.
You managed to save 30 seconds.
Was this set at 30 or 20? I don't remember.
You've got 30 seconds left.
I'm done. Thank you very much for
Thank
listening
you.
this morning.
I think, Mr. Costa, are you going first?
Yes, Your Honor. Check and see if it's still this morning.
Just about still this morning.
Good morning. May I proceed?
Of course.
Thank you. May it please the Court, my name is Matthew Costa. I'm the attorney for the plaintiffs' appellees in 2022 P1026, and those people are John Jenkins, Heather Bodwell, John Ayers, Ryan Eaton, Stephanie Eaton, and Andrew Vrostek. And they are a group of individuals who appealed the planning board decision that led to the land court decision and then led to this appeal. And it is important to remember this is an appeal from a planning board decision, and the planning board's stated rationale for asserting that this land was in the DOD district was they cited what we interpret as a dimensional requirement, and the planning board posited that the site was in a DOD because it consisted of 25 acres. They didn't say it was a town-wide district or anything of that nature, and they cited the section of the bylaw that refers to the 25-acre dimensional requirement. In the land court, on behalf of my clients, I argued that that interpretation opened up, basically, if taken on its face value, was construing the DOD to be basically a floating zone where anyone who assembled 25 acres could establish that they were in the DOD. The land court recognized that argument and its validity. Under the Massachusetts law, floating zones are not allowed. Chapter 48, Section 3 states that zoning districts have to be established by with set dimensions. They can't float. There's other nuances in the law that kind of create some gray areas around that, but basically, floating zones aren't allowed. And so here with the appeals court, the developer, the appellants, they have a different set of arguments. They haven't advanced that argument about the 25 acres because we suggest that that would open up the interpretation that this is a floating zone. And so now the argument is that this statement of purpose in the bylaw created a town-wide zoning district. And we submit that that's not even a remotely plausible, reasonable interpretation of the bylaw, and that the bylaw is not ambiguous. For something to be ambiguous, it has to be reasonably subject to two meanings, and more of the context has to be taken into account than just one sentence out of a bylaw. So we submit that this is a zoning bylaw. Part of interpreting it is to understand the underlying law that we're dealing with. This is a bylaw that exists under Massachusetts General Laws, Chapter 40A. It exists under the precedent that exists under that statute, and it exists according to the procedural requirements for adoption of zoning bylaws. And
So does it matter that Article 26 and Article 27 were sequential? Or what's the relevance, I should say, of the sequence?
So I want to be clear that our position is that is absolutely irrelevant. There's absolutely no basis for that. Attorney Bobrowski, he pointed out that he's been to some town meetings, and to the extent that that's relevant, I have as well. And the town meeting is the legislative body of that community. There's no basis to disparage
So if
it.
Article 26 was approved, and then what's the basis of Article 27 is approved at Article 32? Doesn't matter.
It's pure speculation, at best, to even to suggest that there's a connection between the two articles. Article 26 stands on its own. It states what it did. It set up 43 Main Street in Lakeville as an expedited permitting district.
So you can have Article 26 without Article 27, but is the reverse true? Can you have Article 27 without Article 26?
Absolutely. Absolutely. And that goes to the point of the underlying law here is that in Massachusetts, a zoning bylaw may be adopted without a designation of the land that it relates to. That's the Searle case, that's the Noonan case. It's fair to say that that's what those speak to. That's a rule that they endorse. So when we read the DOD bylaw, we don't have to assume, we don't have to reach for what land does this relate to. We can read it and allow the bylaw to speak for itself and to have a common sense interpretation, which one of the cases that's cited by Attorney Barbrowski speaks to, part of statutory interpretation is a common sense application of the enactment. So when we read the bylaw as a whole, not in isolation, not the DOD by itself, every time the town meeting has rezoned anything except for the DOD, it's not only has a statement of purpose, there's other examples which I cite in my brief where they say this bylaw applies to the underlying districts. Accompanying that is a very specific statement somewhere about where the district is, where the zoning district is. And we have, and to tie this into the legal landscape, under Chapter 40A, the state legislature has said that zoning districts must be shown on maps. And essentially, there has to be some...
But what if the zoning district applies to the entire map? I'm not saying it does here, but hypothetically, then what would they, as a matter of practice, what would you do? How do you show that on the map?
I would expect something similar to the Water Resources Protection District, where the town meeting has said this district applies to the entire town. That's such a simple statement to include.
And that would be in the bylaw, not on the map, or both?
Well, that's an interesting point, because if we look at MGL Chapter 40A, Section 4, it states that, and let me get the language right. Just want to cite it accurately. It states that districts shall be shown on a zoning map in a manner sufficient for identification. So if I was a stranger to a community and I was trying to interpret a bylaw, this ties into the last argument in my brief, I would read the bylaw and I'd look at the zoning map, and that's the reason. So, and then it says, such maps shall be part of zoning ordinances or bylaws. Assessors or property plans may be used as a basis for zoning maps, and it goes on from there. So I would accept this precedent, I think, on the trial court level that basically says, well, even if there's not explicitly a map, like we have examples in Lakeville where other districts, there's a meets and bounds description. That's an exact legal description of where the district is. Or the bylaw says it applies to such and such assessor's parcel. And I'm not challenging that, that's legitimate. What I am challenging is...
So it doesn't have to be shown on the map? It can be described in a bylaw?
I guess I could interpret that as it's reference to some kind of map. You can map out a meets and bounds, anyone with enough skill can map out a meets and bounds description and figure out where it is. It does translate into a map. Of an ambiguous reference such as what the appellants
So I'm sorry to interrupt. So you're the one who points out that the open meeting notice referred to the map. So did they just forget to put in the map? It looks like, your argument is that they intended to amend the map, and there's two places where it shows that they intended to. In fact, but they just forgot?
I'm not going to, I can't speculate. All I know is that's what the notice said. That's what was reported.
I mean, so doesn't that kind of go against your argument that they were planning to amend the map later?
No, actually, so if I were to speculate, you know, I might, there might have been a map, and maybe if there was a planning board meeting, and maybe the planning board decided it couldn't recommend a specific parcel of land, and then the bylaw went on and it was voted on, but no, the town meeting wasn't asked to have any map amendment. There could have been, and what one would often see in a town is there's a warrant article to accept the bylaw. Then the next article might be to see if the town will vote to add such and such parcel of land to the such and such district as accepted in article whatever. We don't see that at the 2012 Lakeville Town Meeting. And so I would submit that really what the appellants are requesting is for this court to stand in the shoes of the town of Lakeville's legislative body. In that it's not, what's expected, because fundamental rights are involved. Everyone in Lakeville's property rights are affected by a zoning amendment. This is, I think, is an expectation that's supported by all the case law that exists, that an amendment like that, it would be explicit. It's not implicit. There's no such thing as an ambiguous zoning map amendment, unless sometimes there could be an ambiguity as far as exactly where a district lies, you know, where its boundaries are. But to say it's ambiguous whether or not the entire town of Lakeville is in a zoning district, that's something that only the Lakeville Town Meeting should decide. And the language we have here in this bylaw, it just doesn't support that. The appellants are arguing that Lakeville did something different with this bylaw than everything else it's ever done in the history of zoning in Lakeville. And
Can I ask you a different question, just because I see that your time is moving quickly? Hypothetically, if we don't agree with Judge Spicer about his floating zone rationale, can his decision still be affirmed?
Yes.
Because as I understand, and maybe I don't understand it, but I think the defendant's argument would basically allow certain portions of residential and other properties to be rezoned within that acreage, and that just doesn't seem right to me.
In the sense that anyone could assemble 25 acres?
Right.
Right, that's what would happen. Which is so implausible. So in the town of Lakeville, these uses that are allowed in the DOD district, they're categorically prohibited in residential districts, many of them. And so it does,
So is your client's objection to the size of the project, the nature of the project, both?
Yes. So my clients, they're abutting property owners all except for one. They live in the residential subdivision immediately next to this development, and they were concerned about impacts, pretty much as what one would expect for a development like this, noise impacts, hours of operation. This would have been, I believe, 24/7. It was undisputed there would be noise impacts on the neighborhood, and so they exercised their rights to appeal. I'm nearly out of time. I'm just going to check my notes to see if there's anything else
My colleagues.
I'm saving something.
So I'll rest on my brief
Just check
unless
with
there's any
Justice
other
Massey.
questions. Okay.
Okay. Thank you. Then we'll now hear from Attorney Maurizio on 22P1024.
May it please the court, it's either the morning or the afternoon, I'm not
We
sure.
finally hit afternoon.
Thank you, Your Honor. I think the most important thing, or the threshold question for this court, is to recognize that this is a question about whether or not a planning board decision, a special permit, should be annulled or affirmed. And under the Zoning Act, Chapter 48, Section 17, that decision is restricted to the four corners of that decision. The land court looked at that decision and found it to be untenable as a matter of law.
Was the land court judge required to give deference to the board, though, to interpret its own bylaws?
To an extent, but as I'm sure this court is well aware, only if that interpretation is lawful, reasonable, doesn't result in an absurd or unlawful result.
And would you say that that result is that, in essence, the entire DOD, or the DOD, would be the entire town?
That was one of the main findings of the land court, but it wasn't the only one. When the land court examined the planning board's decision, where it cited section 7.9.3.2, not the section that the appellant cites, the appellant completely ignores the planning board's decision, tries to come up with some other argument, because the planning board's decision as a matter of law is untenable, because it cites what's called in zoning law a dimensional requirement, a minimum lot size. And if the planning board were to interpret that 7.3.2, it must interpret it consistent with the whole bylaw, not just that one paragraph. And throughout the bylaw, as I've put out in my brief, minimum lot sizes are throughout the zoning bylaw in almost every zoning district. It says lots have to be certain sizes, certain dimensions, etc. I point out that the mixed-use development district, which the Lakeville Town Meeting adopted in 2003, 9 years before the DOD. In that district, it specifically applies to the Lakeville Hospital site, and it says a lot has to be a minimum of 3 acres. So this concept of minimum lot sizes are not for defining the boundary lines of a zoning district. It's for whether or not a particular piece of land that happens to be within the defined zoning district qualifies for whatever type of development is allowed in that district. They're entirely different issues. Identifying the boundary lines of a zoning district and what lots within a zoning district qualify for what uses.
Can I ask you a real basic background question? Since you're arguing about we should be looking at the four corners of the decision, what's the distinction between your two lawsuits?
The distinction?
You have two different lawsuits here. What is yours and what's his?
Just different clients.
So it's the same, both challenging the granting of the special permit?
Yes, right. Yes, sir.
Okay. You say starts, I think, at page 12 of your brief that there was an interim enactment that required a second enactment by town meeting to define the district's boundary lines, excuse me. What do we have in the record to support I know you use the word interim, but what evidence is there that this was an interim enactment other than the fact that there was nothing on the subsequent map?
Yeah, well, that's the most important reason.
Is there anything else I can look towards?
Yes, because remember, Section 4 of 40A, the Zoning Act, specifically, as my brother mentioned, said that zoning districts, it says has to be on a map, but they have to be identified. You can't just say, here's a zoning district. It's wherever it might fall.
If Mr. Bobrowski was right that it applies to the entire town, would it be sufficient to sort of add to the map, the DOD applies to the entire town and leave it at that? Is that all it needed to do?
Certainly could have done that. But the other argument that I think I have great problems with, the appellant's argument, is this Article 2627 notion. First of all, never made before the trial court.
You say that that's waived, right?
I say it's waived. But on its face, you know, to the extent the court wishes to delve into legislative intent, I would point out that Section 5 of the Zoning Act lays out a legislative process. Keep in mind, it's the public that is the legislative body at town meeting. And so Section 5 says the public needs to be informed, not just at the night of town meeting, but through a whole process of legislation, beginning with the planning board. So we have in the record James Merritt's affidavit. He says he's the drafter. Now, he's the chairman of the planning board, and he served on the board, according to his affidavit, for around 34 years. And he held public meetings. And in those public meetings, and he says his intent was that the DOD district would apply to the Bartlett property, which was 104 acres, I believe, or 105 acres. And in the process, he testifies that they dropped the zoning map amendment, and they said that which land this applies to will be dealt with later. And in his affidavit, he talks about how the Bartlett land was later brought up to be subjected to the DOD, and town meeting voted it down. But you have a public hearing process at the planning board, and the public hears it, the public is informed about what it is, the zoning change is all about. And then it moves to the Board of Selectmen, and they do the same thing. They have public hearings, public meetings about what the zoning change is all about. And then the selectmen place articles on the warrant in some order that has really nothing to do with the subject matter, except perhaps they may group all financial appropriations in one section. They may put all zoning matters together in another section, but it doesn't mean that each article is related to the other.
So let me ask you in terms of sort of the ramifications of this case, and I don't think necessarily that we can consider what town meeting has done as a result of this case, but the issues that are raised in this case, does this come up frequently in the area of planning board and special permits for purposes of, is this a case that we need to publish, or is this sort of, use this very loosely, but a sort of a one-off for this factual pattern?
No, I think it should be published. I think it is a very, very important decision because it deals with a couple of things. Can an appellate, a land developer who's the appellant, can they come up with their own arguments that have nothing to, that are totally contradicted by the underlying zoning decision?
One would argue that happens every day in any context, right?
Yes.
So I guess what is the critical legal question? Not what arguments can be developed. Lawyers are great at making arguments, but what's the guiding principle here that you think would be helpful to the bench, to the bar, to planning boards, town meeting, et cetera?
I think floating districts is the most important. Unlike what counsel said, floating districts happen whenever anyone other than the legislative body, in this case town meeting, can move a parcel of land in or out of a particular zoning district. And it has happened in this case. I cite the deed that's in volume 1, and I look to page 233. That's the conveyance a few days after this special permit was issued by the then landowners to the RHINO developers and partnership. There are different legal entities. This was just
33 is the legal description, is that what?
That's right.
Okay.
That's right. And if the court were to look at parcel 3, you would see that there were 3 lots accepted, excluded from that conveyance. So before this conveyance, and I focus on lot 7A all the time, it's the easiest. It's 3 acres, it's shown on other maps. So before this conveyance, this was part of the 49 acres. Now the landowners convey it to the ultimate developer, but they hold back some of the land, a 3-acre parcel. So that 3-acre parcel, under the appellant's argument, was part of some parcel of land more than 25 acres, and then when they deed the property out, they hold it back, and so then our 3 acres is no longer part of the DOD district. So the landowner controlled whether or not his land was in that district or out. And that same activity can happen in the reverse. Two neighbors get together, they're in a residential district, they can make a ton of money by selling their land for an industrial warehousing use. And so they put their two parcels together. Maybe it's even a farm, but it's in a residential district. And all of a sudden, boom, they decided that their property should be within the DOD district merely by the size of their land. And all the neighbors that have homes next door and around that, under this argument would suffer. That's not how it's supposed to happen. That's a classic floating zone. That's left up to town meeting to decide. As Mr. James Merritt said, when they tried to put the 104, 105 acre Bartlett property to the DOD district, town meeting said no. So that's the biggest harm, and the planning board was well aware, as you can see in the record. Both myself and Attorney Costa notified the planning board that what they were considering was improper, illegal, principally as a floating zone. You cannot have, and this is a residential district, the Lakeville Hospital is a residential district for the most part, and you cannot have the property owners in a residential district deciding for themselves without town meeting that they can, sell their land to a commercial developer who will put in an industrial use. That's not allowed.
Can you explain to me an argument you make on pages 25 and 26 of your brief? You're trying to explain the basis for Article 26, and you say that it was Article 26 expedited permitting for the site applies to a different bylaw that did pertain to the Lakeville Hospital site, the mixed-use development district.
Yes.
And you say Article 26 provided expedited permitting for uses proposed under the mixed-use development district. What's the basis for that?
Because the mixed-use development was enacted in 2003. It was specific for this site that we're talking about today. It did not list warehousing use as an allowed use. So the legislative body said, we recognize we have this old hospital. It's been closed since the early 90s. This is what we want to do with this property. 43D simply expedites the permitting process. I think it can only be concluded by looking at 43D, Article 26, and the existing legislation that all legislative bodies are deemed to have knowledge of, that they already enacted something special for the for the hospital site, and now we're going to do expedited permitting. Those two go together.
So anybody who wants to apply for a permit for that site will be expedited, is what?
Absolutely, absolutely. But they're subject.
But not for a warehouse.
But not for the DOD district, which is a classic two-step. James Merritt, who shepherded the whole thing through 9 years after the mixed-use development bylaw was passed, he said it was all about the Bartlett property.
So what about the argument that Mr. Bobrowski makes that you can't attribute the intent of the town meeting to him, to the drafter?
With all deference to Attorney Bobrowski, he argues both sides of the same issue. He says, let's get into legislative intent. And there's the guy who was shepherding the whole legislation through town meeting.
Can, like, a member of Congress testify, this is what I meant when I proposed this law to Congress?
Well, Congress, of course, is a different animal. They function differently. There's not a...
And what about, this also bothers me. The affidavit of merit was in a motion to supplement the record, which the judge denied, right?
He didn't deny it. He didn't act on it because he'd already written his decision, I believe. And
well,
as you read his...
the appendix actually does include on 7/28/22, plaintiff's motion to supplement summary judgment record with material affidavit denied as motion is untimely. That's on the docket.
Maybe it is, but I think Judge Spicer, as you read his decision, he didn't need to go that far. And I point out again that this argument between Article 26 and 27, because it's sequentially at town meeting, was never presented to the land court. It was never there.
You have very little time left, so let me ask you, why are you entitled to fees?
I think this is beyond question that this is an appeal that has absolutely no foundation. at all. Again, it's a challenge to a zoning decision, whether it should be annulled or affirmed, and that zoning decision doesn't make any of the analysis, doesn't make any of the arguments that the appellate has now come up with as they try to find a different route to their end, which is the development of a massive warehousing operation in a residential district.
And we will need to leave it there. Thank you both. I want to thank all counsel. Very well briefed, very well argued. The matter is under advisement. This will also conclude this morning's sitting. I want to thank our court officers, our law clerks, and our timekeeper. We are in recess.
All right.